volunteers. We're going to get started today. So today we have Sree and Jason. Thank you so much for coming. So Sree is the Executive Director of Blue Tree Allied Angels, leverages his background in engineering, law, and business to identify and analyze early stage companies for potential investment opportunities. In addition, he assists management teams of early and mid-stage companies in developing an IP strategy that complements the company's business strategy. Sree's work experience spans various fields, including artificial intelligence, medicine, data analytics, and consumer goods. Independent of industry, Sree works with companies to identify what differentiates them from their competition and determines what forms of IP provides them the best strategic value to protect the differentiation. Prior to joining Blue Tree, Sree worked as an IP litigator and an IP prosecutor at two top law firms, Ropes and Gray and Stern Kessler, as well as assistant chief IP counsel for Dynamics, Inc. In addition, he was a validation engineer and team leads for Intel's microprocessor design business unit. Sree holds an MBA from Carnegie Mellon University's Tepper School of Business, a JD from the George Washington University Law School, a master's and bachelor's in electrical and computer engineering from CMU, as well as a bachelor's in cognitive science. Beyond working with specific companies, Sree frequently presents at conferences on how investors can analyze IP strategy and how companies can improve the efficiency of their IP spending by taking ownership of their IP strategy. And then we also have Jason Somma today. So Jason assists established technology firms, investors, and entrepreneurs in a diverse array of transactional and intellectual property matters. Jason's legal and business consulting practice range from intellectual property, transactional due diligence, data privacy, and other issues, with a particular experience in intellectual property and venture capital transactions related to early stage companies and academic institutions. He is a registered patent attorney with over a decade of experience managing and prosecuting multinational patent portfolios. Before this current practice, Jason spent time practicing in two boutique intellectual property firms and academic technology transfer. He was previously head of due diligence for Blue Tree Allied Angels, where he led efforts for investments into seed and series rounds for technology companies. He holds an MBA from Carnegie Mellon University and a JD from the University of Pittsburgh, where he also earned undergraduate degrees in engineering and physics and music. So thank you for coming, and I'll let you guys get started.
Thanks, Allison. I'm going to share my screen so we can put up our presentation, and then Sree and I'll take it away.
And as Jason is doing that, I'll just give everyone a quick update. So as you heard our backgrounds, but basically think of Jason as people who couldn't figure out what to do with our lives. So we went for engineering, law, business, all this other random stuff. But where we really found our passion is in taking our knowledge of patents and IP in general and helping companies figure out how to get the best value out of their spend.
Yeah, and so Sree, can everybody see the presentation?
Yes.
Yes.
Perfect. All right. Well, thank you, and thank you, Allison, for that great introduction. So I think the big takeaway today, regardless of anything else that you take away from this talk, is that your business objectives should be what drives your intellectual property strategy. And so we like to put up this sort of triumvirate of concepts that your technology and R&D development, your patent strategy and your business strategy should all feed together. In doing that, you work to build your intellectual assets that will ultimately be able to underpin and drive a substantial amount of the businesses and entrepreneurial endeavors that you're working on, regardless of whether it's a technology business, which is what we're focused on mostly here today because we're at Carnegie Mellon, but it could also be a creative business or other kinds of endeavors that you're working on. So again, your product development, your intellectual property strategy, and your business strategy should all work together. And we like to also show this slide because it shows that your business objectives drive IP strategy in large companies. And so there was a survey that was done a couple of years ago by Clarivate Analytics, where they asked some of the leading technology companies in the world about what their highest priority are related to their intellectual property operations. And the number one answer, and it wasn't even close, was that they needed to align their IP strategy with their business objectives. And so I imagine a lot of people today are going to be working either on business or product or engineering aspects of their companies, whether it's a startup that you're working on now that you're building in the sports center, or it's a established company that you're going to later. You're going to have to be the ones who drive the business side of it, because you can work with your IP counsel, you can work with whether they're inside or outside of your company. You're the one who has to understand and drive the business objectives and be able to enunciate the clear reasons why you're building what you're building, and make sure that you're working to develop a strategy around your intellectual property assets that buttresses and ultimately drives your business.
And following up on that, speaking in a little bit more plain terms, lawyers are great at telling you what is or isn't legal, but they don't have the knowledge of your business to be able to tell you whether or not you should spend money on it. What your job is as entrepreneurs is to really understand what it is that the IP can do to help your business, and then let the lawyers figure out how to get that IP for you. And so what our talk is really about is, what are the levers at your hands? What are the decisions you have to make before you go to the lawyers? And then supplementing that, how much is it going to cost you? And how do you justify that expense in terms of future value?
Absolutely. So today we're going to talk about essentially how your IP can end up being concrete shoes that can weigh down your startup or your business. How can intellectual property ultimately be a lifeline that can extend or give you runway, or to be able to derive new business for your firm, and ultimately, as Sri mentioned, how to make informed decisions so that you understand the business underpinnings that ultimately buttress your decisions around your intellectual property strategies and portfolios. So intellectual property is concrete shoes, and the main point we want everyone to take away is that poor intellectual property strategy can weigh down your business. Because useless IP assets waste valuable resources. It can waste your time in trying to obtain them. If you're looking at filing patent applications, it can get very costly and time consuming to obtain them. If you draft poor patents, it'll limit your protection, and ultimately your competition is going to be able to practice your invention regardless of these poorly drafted patents. Another key point to understand is that patents are geographically limited, so it's country by country. If you want to obtain protection in a country outside the United States, you have to go and file in each individual country that you want protection in. And when you start multiplying that over multiple inventions, over multiple patent applications, it can get extremely expensive to maintain a worldwide portfolio. So it's important to understand where you're going to derive the most value based on the rules and regulations around protection and patents, as well as where you're going to be able to enforce them, as well as where your competitors might be practicing. And another key point is that there are many, many avenues to invalidate an issued patent. So once you get through the point where you've prosecuted and gone back and forth with the national patent offices and they issue you or your company a patent grant, there's all kinds of proceedings through litigation or through re-examinations or IPRs in various patent offices that can ultimately invalidate the patent that you spent tens of thousands of dollars on to obtain. On the other side, this poor management can shrink your business value. There are issues related to joint ownership, where if you co-own a patent application with someone else, in the United States, they can practice that regardless of the license rule, but when they're outside the United States, typically the law is reversed, where joint owners need permission from each other in order to be able to work together. So it's important that if you do have co-owned or co-developed intellectual property, that you understand how you're going to be able to work together or potentially not work together. There are issues related to failure to assign patents to or other intellectual property rights to your company, and that's something that comes up very frequently with startup endeavors. You're working together with some of your classmates, you might even be working together in the sports center. All of a sudden, you've developed this new novel technology that you're going out to commercialize, and it becomes really valuable, but somebody walks away from, or they haven't assigned their patent rights to the company, and there isn't any kind of automatic assignment without an employment contract or another assignment contract to the company. So it's important to make sure that gets buttoned up. You could possibly expose trade secrets if you're not managing your intellectual property strategy correctly. You also might be able to showcase and tell your competition what your competitive advantage is, and give them a head start in either copying it or trying to beat it. So it's important when you're thinking through how you're going to develop your intellectual property strategy, how you're going to manage these assets, that you keep concepts like this in mind and understand that if you don't do it correctly, you can either waste time, money, or ultimately shrink the value of your business.
And so if you think about it from your perspective, and if you look at it from my perspective as an investor, when someone comes to us, oftentimes the entrepreneurs are told, get a patent, it'll add value, it'll make it more easy for you to raise funds, that, and that is true if it's well done. But if it's not well done, Jason and I have seen any number of companies that when they come to us and say, we'll ask them, what is your patent? What is the defense? Because you're an early stage company. How are you going to stop someone from copying you? And they'll say, well, we have a patent, or we have 5 patents, or we have 8 patents. And think about each of those patents is a $50,000 cost. So you need to drive $250,000 of value of it. If the reason you got the patent, the best you can tell me is I got a patent so that I can have a patent, that's not good enough. We need to know why. We need to know how you're going to drive value out of it. Otherwise, as Jason just mentioned, it's going to cost you money. It's going to cost you time. Translations into other languages are very expensive. You're giving up. You're telling everyone in the world what you're doing. So in view of all of that, you need to show us how you're going to use all of what you get out of it to overcome all of those disadvantages that come with it.
But on the flip side, your intellectual property can be a lifeline, and they can help your firm obtain capital, encourage business relationships, and even develop customers. So related to fundraising, venture capitalists often like to see patents, particularly depending on what vertical or technology area you're working in. They can be used as collateral for litigation finance if you need to go into enforcement and you're looking at trying to monetize your assets that way. They can serve as a loan collateral. You can also use field of use licensing to license off the right to use your technology in adjacent or other fields where you're not planning on commercializing and develop revenue, basically on the side of your business that wouldn't be there otherwise without your intellectual property rights. You can also develop a ton of relationships and use your intellectual property as a way to underpin those. So developing new customers, engaging in joint ventures, cross-licensing where there is technology that your firm might need from another company, you can essentially agree to share patent rights between each other through a cross-license. It can also give you negotiation leverage and getting better terms. If you have patented technology or other intellectual property rights, they're going to think twice about their best alternative to a negotiated agreement, because the best alternative may end up being extremely costly litigation in order to fight a patent infringement case from you. And there can also be defensive strategies where companies are going to think twice about suing you for infringing their patents if you have a very strong, well-drafted portfolio that could be potentially asserted against them.
And in here, the thing that everyone needs to think about is when we talk about IP, a lot of people think about patents, but really IP is everything and anything that makes you special, that differentiates you from your competition. And what I want to know as someone who funds companies is, if I'm going to fund you, how are you going to be able to maintain your competitive advantage over everyone else? Your competitive advantage might be your technology, so patents. It might be trade secrets. It might be customer lists. It could be the brand you're developing, trademark, trade secret, you know. So there's a lot of different types of IP assets. What we want to see is that you, as the owner of the company, are thinking about how you strategically invest and develop these assets such that you build up your own company and create this way of protecting whatever it is that makes you special, why it is that your customers are buying your product, whatever it is that drives those decisions. How are you protecting it so that we know when we invest in you or when you get to exit that someone is going to say, this is valuable and you've done a good job in protecting it?
And so further along these lines, your intellectual property really can encourage business relationships. And so sort of drilling down on some of these points, joint ventures are a key thing. A lot of times one company might not have all of the resources, whether it's business know-how, capital, management, or intellectual property rights to be able to build a new product. But one, two or more parties might be able to come together, form a new entity, put their resources into that joint venture. And patent rights in particular can be a really key asset in consideration when engaging in a joint venture, because freedom to operate can become a really important concern, and it can allow parties to otherwise obtain unavailable rights that if any party acted alone, they wouldn't be able to go forward.
And so to talk a little bit about that, so what Jason means when he says freedom to operate is a joint venture often allows you to use your co-founder's IP and them to use yours to do different things. The really strong point here when you're looking at this slide is that very last point. The very last point is so important because of what you are agreeing to can make or break everything moving forward. If you give away too much, there's chances that you might have just caused yourself to have a roadblock in you doing anything that you want to do in the future. And if you don't give away enough, you might put yourself in a position of getting sued by your partner because you haven't actually negotiated these rights correctly. There's key points about who owns what. Everyone wants to say that we own everything. But honestly, sometimes you don't want to fight. You don't want to spend $50,000 on a patent if they're willing to do it, as long as you get access to it. Or maybe vice versa. Maybe this is very important to you. Maybe it is that it's a large company you're working with. And even if they get the patent, maybe they won't want to sue a potential infringer because it's one of their clients. And all of a sudden, they're letting your competitor use the technology for free because it's one of their clients. So there's a lot of issues and a lot of knowledge. Joint ventures are very dangerous. They're very valuable, but you need to go in them with your eyes open and know what you're agreeing to and be very clear about what you're agreeing to.
Absolutely. And I think key to joint ventures as well as to all kinds of intellectual property rights, if you get them right from the beginning, they're going to drive the most value for your company and the relationships that you build. So it's important, I think, for everything that we talk about, the earlier you can figure these things out, the earlier you think about each aspect that you're working on, the better it's going to be. And it's a lot easier to take care of any of the issues that crop up earlier than later. So another key relationship that can exist is cross-licensing, which we alluded to before, which is when two or more parties grant each other access to patent rights that the other needs. And so there are tons of examples around cross-licensing. It might be the most common form of intellectual property right sharing. A really famous one is Google and Samsung have a very broad cross-licensing agreement for patents related to the Android operating system for smartphones. There's also patent pools where there are multi-party portfolios of patents where everyone includes their patents, which are often standard essential patents, into the pool, and then all those parties are able to share those rights and avoid infringing anyone else's patents. And go ahead, sorry.
And this sounds very much like it's a big company issue, but it affects all companies of all sizes. So if you think about it, let's assume you're manufacturing a product and you have some very key knowledge about your product, what you want made. and they have some very key knowledge about how to make it. So there is a place where you guys are cross-licensing, even sometimes where you don't know it. And it's good to just know, okay, they're our key manufacturer because they have certain key abilities that we want really access to. And they want our business because, you know, we're paying them one. And this is a very interesting technology that they want to be able to say they are the ones that made it or manufactured it. So there's always, from small businesses to large businesses, these cross-licensing agreements appear basically everywhere.
Yeah, that's absolutely right. And it can be a big issue for startups in particular because they can be a barrier to entry for startups. And so it's something to be mindful of, that to cross-license, you need to have assets that the other parties want, and they have to have something that you want. And if you don't have something to give in return, you can run into problems about just being able to access those rights. And lastly, and what's becoming a slightly more common issue, and then it'll be interesting to see how this works through the Biden administration now, they can receive regulatory scrutiny for various reasons, most notably for antitrust purposes. And enhanced scrutiny might cause problems down the line when it comes to exits. And so it's something to be mindful of. It's very rarely an issue that should stop you from engaging in these activities, but it's something to be careful of, that if you get big enough and you have broad cross-licensing agreements that may be viewed as anti-competitive, there might be regulatory scrutiny attached. But patents can also encourage your customers to purchase your products because, one, it can be a key indicator of quality in that what you've done is novel enough to receive a granted patent. It can also provide some assurance that your product isn't going to become obsolete because a competitor comes in and builds an improvement that otherwise would require your background in intellectual property or practice. It can also reduce the risk of customer patent infringement, and this can be a really key point for your customers. It's super important in patent-centric industries such as pharmaceuticals, where the patent rights essentially are the sole reason beyond efficacy why companies that invest in R&D and developing new drugs are able to derive profits from them. And the Uniform Commercial Code, which is the law that underpins commercial transactions in the United States, includes a clause on patent indemnification for products that are purchased. So if you buy a product from a patent-owning vendor, they have to indemnify you in certain cases under the Uniform Commercial Code, and it can very much reduce the risk to them, and so that can induce them to purchase from you. Also, portfolios can be used defensively, and the strategies can be key bargaining chips in negotiations. So if you're threatened with patent infringement, if you have a strong intellectual property portfolio, it can be a bargaining chip that can be used to either settle that litigation or make it go away. Better portfolios can lead to better settlement terms, or, as we mentioned before, it can actually be an instance where cross-licensing technology can be part of that settlement that wouldn't otherwise be available if you didn't have those rights.
And here's a key area where it's important for you as the company owner to be clear about what you're looking for from your from the patents that you've been granted. So specifically, when we talk to our companies about how do you get a patent, we often talk about the 20-year life and creating a tree, and there's a lot of terminology we use. But basically, the long and the short of it is, if you have a very good patent portfolio that is very protectable, can't be attacked, or if it's attacked, you can fix it. So it's why we say, I'll explain the tree analogy for one little second. Basically, if someone attacks your patent and actually invalidates it, knocks it completely out, in most cases, that's the end of the story. You've lost everything you spent time and effort on, except for if you still have a piece of that patent pending in the patent office. If that's the case, you can fix whatever problem they found with it and reissue a new patent that has any problems they found fixed. And so that's a huge ability to change the negotiation. So if someone comes and attacks your patent, it's a $500,000 to $1 million process to invalidate a patent. If you can go and tell them, look, that's great, if you invalidate our patent, we can we can grow another one, we can issue another 3, another 5, because we have something pending at the patent office. That gives you a much stronger negotiating position to say, drop this, let's cross-license this and move forward, rather than let's go through $1 million patent lawsuit to invalidate our patent. It just changes what everyone's incentives are for the negotiation. And so in having a good strategy and thinking about it when you file the patent, gives you a lot more opportunities further down the road.
Another interesting point is that patents in particular and strong intellectual property strategies can provide returns on R&D even when your products aren't successful. So one very good example of this is Kodak. So up on the screen are 2 very early versions of digital cameras that Kodak developed. The original one being in 1973, the one on the right, one that was circa 1989. For people that aren't very familiar with Kodak or how their camera technology developed, Kodak spent a ton of money on building and developing digital camera technologies and ultimately wasn't very successful in commercializing it. But even though they weren't successful in building and selling their own products, because they had developed a really strong intellectual property portfolio around that digital camera and digital picture technologies, they earned over $3 billion in licensing over the course of that patent portfolio, and ultimately were able to sell off the rest of it as part of their bankruptcy. So even when Kodak lost on its business and ultimately was able to continue because they spent so much effort on trying to maintain their film technologies, the fact that they had developed a really strong R&D program, built a really strong portfolio around their digital picture technologies, they were able to derive a ton of value, and ultimately at the end of the life of, before that bankruptcy, was deriving a substantial portion of its profits. Your IP portfolio can also be a really key aspect to raising capital. And so we're going to talk about a number of things related to this, but a key point that has been found in academic research is that there's actually a really strong increase in the probability of raising venture funding once you've gotten a granted patent. And in this study, they said there was a 59% increase in the probability of raising venture funding. What the study found is that it's really beneficial, and patents are really beneficial for early stage startups, particularly those that are founded by inexperienced entrepreneurs, or in places where they're operating where they're not having, they don't know their funders as well, or the entrepreneurs don't have a track record. Partly, and the reason for this is that it mitigates information thresholds, because you can share your technology and the underpinnings, knowing that it's protected, without having to sign a non-disclosure agreement or rely on some sort of contract or trade secret theory. And that's important because, as Sri knows, and it's very uncommon that a venture capitalist will ever sign a non-disclosure agreement with you. And so it's important, and patents can be a really key part of your strategy, because if you have a patent application that's published, or better yet, you have a issued patent application, you can share it and no one else can practice that technology without coming to you first. You reduce the risk on your side of someone copying or being able to practice and compete against you. It gives your investors some comfort in knowing that your technology has some sort of novelty and non-obviousness around it. And it allows you to freely share information around your technology so they can do due diligence on your technology and ultimately decide whether to invest. And I thought another point that was also pretty interesting in this study is that by having a granted patent application, it actually doubles their IPO probability. So it is really important to understand what your patents can do for you, what other aspects of intellectual property can do for you in a company, and use those to your advantages when you're going out to raise capital.
And while this was really focused on patents, the idea stands for all of IP. So if you think of a company that's focused more on branding, more on fashion, more on other types of IP, it's still extremely valuable, because what venture capitalists are looking for is what I said before, that you know what it is that makes you special and that you've protected it. You know what it is that's patentable and you've protected it through patents, you know what it is that you don't want to tell anyone. What's your secret sauce? And you've protected it through trade secret. You know what your brand stands for, and you're emphasizing that in your marketing materials. You know what it is that is in your customer deck, your customer list, your Rolodex that's really important, and you're making sure your salespeople don't walk off with it. It's in that knowledge, in that IP, that we want to really make sure that you have it locked down, because that's what we're really investing in as VCs.
Absolutely. And it's also really important to understand how intellectual property plays in your industry and how it plays in the geography of where you're located, because both of those are key points to understand when trying to discern how venture capitalists are going to view your intellectual property portfolio. So for example, if you're running a life sciences company, patents are.
It looks like Jason might have frozen. Can anyone else see Jason?
No, he's frozen.
Okay, got it. So what he was saying was, in certain industries like pharma, patents are everything. If you have a patent on your drug, you're good to go. You can get orphan drug indications, you can get regulatory exclusivity, and no generics can copy it. If you don't, your drug is useless and will be copied. In other industries, it's different. So for example, in the software industry, patents don't matter quite so much, because it's easy. One, easy to get around. Two, it's hard to determine whether or not someone's infringing. No judge is going to let you look at someone else's code, especially your competitor's code, just because you think they might be doing what you say you patented. So their trade secrets matter more. Their branding matters more. All industries have their kind of own interests, their own value in what is the most important thing. I'll bring up the presentation in a little bit, but this is kind of a good area for us to kind of take a little break and ask. If anyone has any questions, please unmute yourself and I'll take them as I can. So that is a very good question from Z. So one of the things we talk to our startups all the time about, so the question is, how costly is it to stop someone from infringing your patent? And the answer is, it is so expensive that no startup will ever do it. A typical patent lawsuit will be $3.5 to $5 million. And if you have that much in your war chest, I'd expect you to be using it for other business building values. Where the patents are specifically more valuable is more in the M&A transaction. Let's assume you've got a good patent portfolio. You've spent money and you've put it together. Sure, you don't have the capital to really fight it, but if someone is going to acquire you, they're going to want to know that they have the ability to protect whatever it is you did. If Microsoft buys you, they have the money to fight that lawsuit. They're not worried about that. But if your patent portfolio, your trademark portfolio, your trade secret portfolio isn't strong enough, it isn't worth their time, effort, or money to even take a look at it. So it's really, when we talk about a strength of a patent portfolio or an IP portfolio in general, it is not about you as your company fighting this in the court of law. Quite honestly, if you get to that point, multiple mistakes have been made and you're wasting a lot of money. It is to get whoever acquires you to be much more comfortable that what they're acquiring is protectable. I see Jason's back, so.
Yeah, sorry, thanks. I don't think I'm trying to share my screen and I can't. So I don't know, Sri, if you can, or if we can talk from the rest of the.
You talk for a little bit, I'll share my screen.
Sure. So following on from slide 21, another thing that patents can do for your companies are that patents are a key criteria in getting SBIR funding for the federal government. For people that aren't aware, that's Small Business Innovation Research Grants. They're non-dilutive funds that at phase one can be six-figure grants, which range depending on what the agency that's sponsoring the SBIR gives out. For phase two, those numbers can climb north of $1 million. And again, it's non-dilutive grants. And the reviewers for SBIR grants, very often look at patents as a key criteria in determining whether or not they're going to fund those applications. The mean value of an SBIR grant, this is a little bit dated, was $850,000 for a phase 2 grant. So there's a substantial amount of money that's available from the federal government to small businesses and startups in non-dilutive funding, where patents are a really key part of that judging criteria. And so it's important that if you're thinking about going the SBIR route or the STTR route, which is another type of federal grant that's similar, that you have a strong portfolio, that you understand how that fits into the funding strategy and the decisions that those federal agencies are making, and they can be really used to help drive funding from them. Another way that patents can serve your fundraising needs, which is something that typically happens in later stage startups or in established companies, is that patents can actually also serve as loan collateral. Because patents and other forms of intellectual property have the attributes of real property, they can actually be used to secure loans. And there's also strong bankruptcy protections, which lessens the risk of lending to companies that file and obtain patents for their technologies.
And so
go ahead.
The key here is not that you are getting, so going to back to one of the earlier questions, the key here is that you're not going to use the patent as loan collateral where you are right now. But down the road, you're going to still, if you think of an early stage company, a lot of your money either comes from friends and family or from VCs early on. That's great. Your stack is pretty. Down the road, you're going to start looking at other ways to get capital. You're going to start thinking, okay, I'll get X amount from equity financing. I'll get X amount from debt financing. I'll look for other things on my stack. At that point, that's where a strong patent portfolio, if you developed it years ago, can really play out to help you get better terms on loans, get better interest rates, get access to different types of loans. So certain people will actually use the collateral and they will actually do the litigation of the infringement and sue other people on the loan based on just using it as collateral from you. So there's a lot of other doors that open up for you down the road if you do your IP strategy right up front. And this exists for all forms of IP. A lot of it just really depends on how well you are versed in the IP strategy.
And so, Sri, if we go to the next slide, we have an example that shows, so this is an example from Mimosa Networks. So they had raised about $20 million in 2014 from various venture capitalists. As part of their growth strategy, they took out a loan instead of taking out more venture financing. And because they had built up a pretty strong patent portfolio, they were able to get loans from various banks and they assigned security interests in their patent applications and their patent portfolio to those banks. And they were able to use that as much cheaper financing in order to finish out the growth that they needed to achieve to ultimately get acquired a year later. So this is not uncommon at all. There are plenty of companies based right here in Pittsburgh that I've known to do very similar things. And it's been very attractive to the venture capitalists who are earlier in the cap table because they're not getting diluted. It's attractive to the entrepreneurs as well because you're just like your VCs, you're not getting diluted. And this is something that has been increasing in frequency over the past 30 years. So this chart shows the number of patents that have been pledged as collateral to loans between 1990 and 2011. I think it shows that it's happening across industries with certain kinds of technologies being much more common. I think it's very common in pharmaceuticals and medicine, in my experience, but it's also interesting that in computing and telecommunications, as well as in certain electrical technologies, that it's becoming increasing part of their funding array to be able to use patents as collateral for loans. And if we go to the next slide, Sri. So that graph is kind of old. It's only increased since 2011. So about 200,000 patents were pledged as collateral from 2012 to 2015. That number doubled over the 4-year period between 2016 and 2019. So it's becoming more and more common. And it's of particular importance for late stage startups when you are getting growth financing, when you've been successful and you're ultimately pushing on towards some sort of exit, whether it's an IPO or an acquisition.
So we're going to take a little bit of a break here, and please jump in with any questions you have, but we'll go through these last few slides pretty quickly.
Yeah. We can just quickly touch on this, and we mentioned it before. Field of use licensing to markets that you're not trying to exploit yourself commercially can be a really good way to derive revenue for your company, so that you don't have to go out and fundraise. An example that is pretty common is that companies that build MRI machines license their MR technologies to oil and gas exploration companies because the technology is very similar, and a lot of times they'll need that in order to be able to have freedom to operate. Since this is Carnegie Mellon, it's a Tepper School of Business. Sri and I are really strong believers that you should have a data-driven approach to decide if your IP will drive value for your business. We go to the next slide. And when Sri and I work together on looking at deploying funds for venture capital funds, we look at the IP portfolio pretty strongly, partly because we are both registered patent attorneys, but also because we understand how much value it can drive for these companies later on, again, in acquisition or for later growth stage financings. And for the entrepreneurs in the room, it's really important to understand how the venture capitalists that you were trying to target evaluate IP portfolios. A lot, especially at the early stage, they're very much not concerned with your IP portfolio because it's something that doesn't affect your day-to-day operations now. And they might look at it as something that can be developed or cleaned up down the line. And so it's important to understand that if that's the way your pre-seed and your seed investors are looking at your IP, that you're not trying to go out with your IP focus first as part of your fundraising strategy.
And so here it's really all about strategy, as Jason just mentioned. The idea being, it might not be depending on the stage of company, it might not be the number of patents that you have, but the quality of the patents that you have that makes more and more value. It might be, how do the patents interact with the trade secrets? Are you managing that knowledge correctly? And to be quite honest, you should know more about your patent portfolio and your patent strategy than the VCs. Quite honestly, they know a little bit about it. They probably think they know a lot about it, but strategy is really the entrepreneur's bread and butter. They need to know why you need to know why you're doing it. Having a strategy of, I'm just getting patents so that the VCs will invest in me, is not a good strategy. It's a waste of money, it's a waste of time, and ultimately it puts your business at risk. You need to know why it is you're getting these assets, how they layer together, just like how your financing layers together, just like how your sales and marketing layer together. This is just one more tool that allows you a way of strengthening your position and really showing that you know what you're doing with your business, and that the VC should trust you with every other decision you're making.
Yep. I think we can move on to the next slide, Sri. And so to sum it up, it's critical to know how those who are funding your business view intellectual property, and to also understand that there's no single best strategy. Patents may have no place in your business. Your trademarks or having strong trademark protection might not have any place in your business, or copyrights or design patents or the other forms of intellectual property may or may not be the right way to take your company, particularly when you have limited resources at the beginning. So what works for you might not work for one of your colleagues that's sitting at another desk, or that you're talking to as part of your cohort of sports fellows here at Carnegie Mellon. And so understand, and your job as an entrepreneur is to really understand how it works for your company. And ultimately, when your business strategy is aligned with your intellectual property strategy, patents can really drive value for your company. And thinking about that from the earliest stages starting today is the way that you're going to be able to drive the most business value for your company. So our contact information is here. Sri and I are both really proud Carnegie Mellon alumni, and we'd love to talk to any of you offline to answer questions later, and we'd be glad to talk through any questions from the presentation or otherwise that we could work with you today.